Considering the second reading of the Family Court Proceedings Reform Bill, the debate is now resumed. Dennis O'Rourke was speaking and has 6 minutes, 30 seconds remaining if he desires to use it.
Thank you, Mr. Speaker.
Dennis O'Rourke.
Mr. Speaker, before the lunch break, I had mentioned that New Zealand First had wished to support this bill, and I gave some reasons why, and fundamentally we weren't against the principle of FDR. But I also said that there would be a number of conditions, and I listed what they were. In the end, despite a very large number of amendments having been made to the bill as introduced, New Zealand First's reservations and concerns have not been met, and so New Zealand First will now vote against the bill. Mr. Speaker, the bill targets the use of professionals, especially lawyers for the parties and lawyers appointed to represent children. Under Clause 5, legal aid will be available only to a limited degree prior to but not during any mandated dispute resolution process, and secondly, if the dispute goes before a judge. New Zealand First does not agree to penny pinching of this kind, resulting in lack of adequate legal representation and with it severely reduced legal aid entitlements. As a fundamental principle of justice, parties with a reasonable need should decide if they need a lawyer, not regulations. Family dispute resolution would be free for those under the income threshold for civil legal aid, estimated at about 60% of participants. So most parties are already legally aided out of necessity. But the availability of legal aid should not be the basis upon which parties decide whether they should have a lawyer or not for these family dispute matters. Mr. Speaker, while FDR is likely to be less expensive in hiring a lawyer and proceeding to a defendant hearing in court, these requirements are so tough that many people, many of the 40% not entitled to legal aid, will simply not get a lawyer when they really need one. And there is also the very real problem of power imbalances being created as a result. These reductions in legal representation and legal aid are the main reasons for New Zealand First opposing the bill, and these reductions are likely to be a false economy anyway, because costs in other areas are likely to increase, and several submitters described why this is likely. Fundamentally, if the quality of the process is compromised, the resolution of disputes may be illusory, resulting in another dispute later. Another reason for opposition is that the bill prohibits the court appointing a lawyer to represent the child unless it is, quote, necessary, unquote. Clause 5 of the bill as introduced would allow a lawyer to act for a party in a proceeding if the application was made without notice, relates to international child abduction, the party is the Crown, a judge has directed the case proceed to a defendant hearing, or the lawyer is lawyer for the child who is party to the proceedings. The concern, though, is that lawyers would no longer be involved in all of the cases where they are needed. The problem is that the bill requires the court to have, quote, concerns for the safety or well-being of the child and consider an appointment necessary, unquote. It should be the other way around. The court should appoint a lawyer for the child unless it finds that it is unnecessary. That is what it is in the current law, and that really is the way it should stay. The official advice is that parents are expected to represent the best interests of the child in the process, but parents in too many cases are not really able to objectively look after their children's interests as one would hope. In these cases, a lawyer for the child is needed, and the test of necessity is too tough. Children cannot always rely on their parents, especially in the stressful atmosphere of a relationship breakdown. The interest of children must be paramount, which is the foundation of the Care of Children Act 2004. This bill fails children in the restriction of independent representation for them. New Zealand First also believes that the full government funding of counselling services should be reinstated. The bill would repeal existing provisions for family court counselling under the Family Proceedings Act and the Care of Children Act, except for up to 3 hours of counselling, and replace them with a new scheme. The provision for only 3 hours counselling is not adequate. Not all families will break up if they get adequate counselling before the other process is used. In the past, most matters were resolved by counselling, and it should be reinstated. The court will be able to appoint a lawyer to assist the court in appropriate cases under this bill, but the parties would have to pay for this, probably a 1/3 apportionment, and Mr. Speaker, that is also wrong and is opposed. Mr. Speaker, another issue of concern to me not addressed by the bill is the lack of enforceability of agreements in the FDR process. These agreements lack the status of a court order. They are likely to be recorded and may be signed, but they depend on the commitment of the parties to carry them out. The risk, of course, is they will simply be ignored. Mr. Speaker, while the bill started out with good intentions and while we are not opposed in New Zealand First to FDR in principle, the overwhelming thrust of the bill is clearly just to save money, and the effectiveness of our family court system will be compromised by this bill. It fails to ensure the availability of adequate publicly funded counselling when it is needed most. It fails to ensure that parties will have legal representation at all stages when they need it. For those reasons, Mr. Speaker, New Zealand First is obliged to vote against the bill.
Katrina Shanks.
Thank you, Mr. Speaker. It's my pleasure to take a call on